in Botswana, in terms of our constitution, particularly Section 86, Parliament makes laws for the nation, for the country, for the people. So it's important that human beings operate within demarcations, within laws. And those laws, somebody has to make those laws, and they're made by Parliament, the National Assembly, as provided for in the Constitution of Botswana. If there is no structure which contains legislative powers by Parliament, then there will be chaos in not just Botswana, in the world. So it is important that in any community or in any society, there are those who are empowered to make the laws so that the society is well structured. The Constitution of Botswana clearly provides for separation of powers. It doesn't say so in explicit terms, in black and white, but in the way it is structured, one can deduce from there that there is it envisaged the founders or the drafters of the Constitution had in mind that there should be separation of powers between insofar as the three arms of government are concerned, the legislature, the judiciary, and the executive arm of government. So officially, there is a separation of powers. But what you can have is an absolute separation of powers, because all these three different arms of government are interrelated, they're interdependent. They ought to be independent of each other, but there is no way that they can function independently. There would always be checks and balances. So ideally there should be, yes, and in terms of our laws there is. But that may well be a different answer when it talks about the individuals on the ground who make up those three different arms of government. The question is whether or not on the ground you have them exercising the separation of powers, exercising their powers, those powers separately as required. What the law provides is very clear that there is separation of powers. The doctrine was envisaged by the drafters of our constitution, but it may well be that on the ground we don't see that because of the individuals that operate on the ground. The three arms themselves check themselves. They check this. The constitution is such that there is provision of checks and balances amongst the three arms of government in terms of law. That's why when the executive crosses its constitutional line, you are entitled to take it on constitutional review, or where it operates, where it encroaches on your rights, whether those are the common law rights or the constitutional rights, you can go to the court, to the High Court, which is part of another arm, or the judiciary as part of as an arm of another arm of government, to take the executive on review. Our law reports are replete with decisions where the decisions of the executive have been set aside on the basis that they are by our courts, on the basis that they have acted unconstitutionally. Or review it and set aside on other review grounds, not necessarily on constitutional grounds. So that happens on a daily basis. Then you have the legislature. The legislature, in terms of law, should also check Parliament, the executive arm of government. The law allows it to do so. As to whether or not it does so as a matter of fact on the ground, it may well be not just a legal question, but also a political question. That the legislature does not do that. There has been questions of the executive arm of government being members of the executive arm of government, that this cabinet being also members of parliament. so that the lines in terms of what happens on the ground being blurred. But we have a situation. We have heard that there is an intention by the political leadership to review the constitution of Botswana. So in that constitutional review process that I think the nation anticipates, the nation will be, called upon to comment. Members of civil society, from also and people from all walks of life will be called upon to comment on how they want the separation of powers, for instance, to appear in the constitution. Do they want it to continue as is currently, the way it is structured, or do they want to have the constitution amended so that they have more independence insofar as those three arms of government operate? Separation of powers doctrine is important it's in the national interest. It's internationally also it's because all well-meaning democracies or like-minded democracies have adopted the age-old doctrine of separation of powers. Without it, there would be chaos on the ground. So one cannot overemphasize the need of the all-important doctrine of separation of powers, which the drafters of our constitution already had in mind, but which, when we do our constitutional review process, we may need to improve how it is couched right now to a better demarcation of the powers of the three arms of government. Having listened to radio calls, social media comments, etc., I honestly think that there is need for more public education on understanding of the Constitution and on understanding of the laws relating to state of emergency. The state of emergency is provided for in the Constitution in Section 17 of the Constitution, which empowers the president to make a proclamation of a state of emergency. That is the starting point. The state of emergency of Botswana is not derived from Emergency Powers Act, nor is it derived from state of emergency regulations. Many people seem to think that state of emergency regulations, the currently applicable regulations, or the Emergency Powers Act are the source of a state of emergency, when that is not the case. The source of the state of emergency is the Constitution itself, Section 17. So when one has regard fully to the provisions of Section 17, Section 17 is divided into, I think, 5 provisions, if I'm not mistaken. But clearly, what is not even debatable there, the Constitution retains the powers of Parliament to make laws. The Section 17 of the Constitution does not give the president the power to be the law unto himself or to rule by decree. That is a misconception that many people fall into when the state of emergency is discussed everywhere. What Section 17 of the Constitution does, it says the president makes that proclamation. But it is very clear that Parliament has to then approve. If the president has to make the declaration. Once the president has made that declaration, there is a time limit which is given for then Parliament to sit and decide whether or not it's approving the state of emergency under Section 17. So that means that Parliament's legislative powers are still effectively retained by Section 17 of the Constitution. You will recall that a couple of in or around March 2020, when during the first when the state of emergency was first, the proclamation was first made by the president under Section 17. Parliament, within a reasonable time, I can't remember when exactly, met. And the question before Parliament was whether or not it should adopt the state or it should approve it. So Parliament approved the regulations, state of emergency, and the regulations relating to the state of emergency, because the president may make those regulations in terms of the emergency, not the Constitution, but the Emergency Powers Act. But Section 5 of the Emergency Powers Act, just taken from the Constitution, is very clear. It makes it clear that the president, so the president's proclamation and all regulations may be revoked by Parliament, set aside by Parliament. So not only does the Constitution, Section 17, retain the powers of Parliament to make laws, also the Emergency Powers Act, which empowers the president to make regulations, which we live in right now, which we operate under right now within our state of emergency, so that the Parliament may revoke those regulations. So at all times, Parliament checks the president. At all times, Parliament, under Section 17 and under the Emergency Powers Act, Parliament has the ultimate decision. It retains the ultimate decision-making power on the state of emergency regulations, because it may reject them. Yes, the president has temporary powers, a couple of days within which to make the proclamation, make regulations, and immediately within the time specified in the Constitution and in the Emergency Powers Act, Parliament has the right to revoke or set those aside. So it is not the president who ultimately decides, in the sense that it's Parliament that retains the final decision-making power in so far as that is concerned. So ultimately, if Parliament is happy with the regulations made by the president or the decisions made by the president under the Emergency Powers Act, approves what the president has done or wants to do under the Emergency Powers Act or the Section 17 of the Constitution, then as the public, if you have to blame, then maybe you have to blame Parliament, but not the powers given to the president under the Constitution and the Emergency Powers Act. It's not the powers that you blame. It may well be the people that exercise those powers, or that have the power to limit the regulations, that may well be to blame. But remember that those are the people that have been voted into power by the citizens, that once they are voted into power, speak for the citizens, make laws on behalf of the citizenry. And that is the democracy that we have adopted. That once we take them to Parliament, they are going to sit there and make certain decisions on our behalf, some of which decisions we would like. What is the law? What does the law say? Does it say what the people think it says? In other words, does it say that the president rules by decree during a state of emergency? Certainly not. The president does not rule by decree, and it's even dangerous to give any person the impression that they have the right, because there is a state of emergency, to rule by decree. And any president who, during any state of emergency in Botswana, purports to rule by decree, can have their decisions reviewed and set aside by courts of law. Right now, we are in a state of emergency. Our courts operate. The High Court operates. The Court of Appeal, they are not suspended. So if the president makes any decision or any regulation that violates one or more of the provisions of the Constitution, the civil liberties, for instance, provided for in the Constitution, you can go to court and have them declared unconstitutional and have the regulation declared unconstitutional. You can't say the court can't say remember, we're in a state of emergency, the president's powers cannot be challenged. No, that's not our law. That's what many people think. And maybe many people who are aggrieved by certain decisions during the state of emergency are afraid of taking the matters to court because they genuinely believe that right now we are in a situation where somebody reigns by decree. That's not correct. That's with respect. It's a misconception, and it's an understandable misconception. If you remember, what I said earlier was that maybe there is need for more public education on how the state of emergency operates in Botswana in terms of our laws. When the president makes regulations during a state of emergency, the president does that in terms of the Emergency Powers Act. So the Emergency Powers Act cannot purport to suspend the provisions of the Constitution. Therefore, you cannot have absolute power. You cannot have any official or state functionary being vested with absolute powers, ruling in that way, because no powers have been added in terms of the Constitution. The president does not have any added powers that he would normally not have in the Constitution, because the Emergency Powers Act and the regulations made under the Emergency Powers Act cannot in any way, shape or form limit or add to the powers, the statutory powers given to the president or the executive in terms of the Constitution. On the ground, you have a situation where the executive, of course, may well have more the numbers competing with the numbers of the legislature, such that it's very difficult on the ground to provide for checks and balances. You will always have a tension between the executive and the legislature caused by the interdependence of the two arms of the state. But there is, of course, may well be a concern that the many members of cabinet on the ground in Botswana are also members of parliament. So therefore, the line is blurred between the executive and the legislature. If that is the case, is that what we want? Do we want the president to appoint his cabinet from outside parliament, and then so that parliament is on the ground absolutely independent, or at least largely independent? So those are the questions that I assume that the society or the public will have to, we will all as members of the public, me included, have to grapple with during a process of constitutional review that we anticipate. Other arms of government, they report only to the Constitution, because we are a constitutional democracy. We are not a parliamentary democracy. We are not a presidential democracy. In Botswana, what reigns supreme is the Constitution. So if we are going to have oversight institutions, let them be provided for specifically in the Constitution, because currently the Ombudsman is not in our Constitution. For comparative analysis, you take South Africa, the public protector has the powers specifically spelled out in the Constitution, and other what they call Chapter 9 institutions in South Africa. But understandably so, because South Africa has a relatively new constitution approved in 1996. Ours is in 1966 with minor amendments, with what I consider small amendments along the way. So now is the time when we do the constitutional review to look at it globally, and say we want oversight institutions to be independent and not to be answerable to the executive arm of government. I think that's the ideal situation. Members of parliament speak on behalf of in our democracy, they represent their constituents. So when they go to parliament, one imagines or assumes that they would have consulted their electorate. There is no overemphasizing the need for consultation with those who took you to parliament as a member of parliament in the first place. Botswana can always be involved in the process of introducing bills by approaching the members of parliament. Because, as I understand it, Parliament has standing orders, and standing orders provide for private members' bills. So that's what Botswana should understand. So when they vote for those, when we vote for our members of parliament, and you have a pressing issue that you would have done your little research and thought it would best benefit the nation by having it made into law or amending a law that already exists, then I think you should approach your member of parliament. That's why you voted for that member of parliament in the first place, to present it by way of a private member's bill. At times, I think it may well be difficult to approach your members of parliament in that sense individually. That's why organizations are also very important, civic society organizations, because these are pressure groups. These are groups that can easily influence decisions in parliament. Because they are organized enough to approach members of parliament, to approach even the president.